Federal High Court in Abuja has dismissed a suit filed against President Bola Tinubu over his March 18, 2025 proclamation of a state of emergency in Rivers State. The proclamation led to the suspension of Governor Siminalayi Fubara, the State House of Assembly, and the appointment of an administrator to run the state for 6 months. The case was initiated by a group of indigents led by Belema Bricks, who argued that Tinubu's actions violated their democratic rights. Justice James Omotosho ruled that the plaintiffs lacked the legal standing to challenge the proclamation, noting that they neither suffered greater injury than other citizens nor had the authority of the State Attorney General to file the case. He also held that only the Supreme Court has the jurisdiction to determine the validity of a presidential proclamation of emergency rule. The court therefore struck out the matters as frivolous and baseless. The judge further upheld Tinubu's claim that the emergency rule was necessary to prevent a breakdown of law and order in Rivers State. He maintained that the president acted within his constitutional powers under Section 305 of the Emergency Act by suspending elected officials and appointing an administrator. According to him, the proclamation was lawful and aimed at averting anarchy and ensuring public safety. Interesting one there. I am interested to know your position on this matter, considering that you are a legal practitioner. So, what do you make of this position by Justice James Omotosho of Federal High Court?
Thank you very much. Nigeria is a country governed by laws. And in bringing actions to court, there are 3 major factors that must be considered by a lawyer and also parties seeking declarative reliefs from the court or claims of all sorts from the court. You need to first of all look at the course of action in this matter you want to bring before the court. Is there really a reasonable course of action? That's the first step. And what do we mean by reasonable course of action? Reasonable course of action is simply those things that will enable a claimant get its claim from the court. So when you look at those set of facts, you look at them very well that truly a course of action arose. Then you can approach the court. Then the second factor one must consider before bringing an action to court is the locus standi. It is a Latin phrase which simply means capacity to sue, or the right to bring an action to court, or the right to appear before the court and be heard. So when you consider all this, you look at the locus standi. This party bringing this action to court, does he or she possess the right to sue or not? Or is this person suing on a representative capacity or not? Then the third factor is jurisdiction. The jurisdiction is simply the power of a court to hear a matter and determine that matter by way of delivering judgment. So when a court looks at its jurisdiction and finds out that the matter before it lacks the requisite jurisdiction, it will decline jurisdiction and struck out the matter. So in this Rivers emergency rule, the judgment of Justice Omotosho is not offensive in any way, or it never authorized the Constitution of the Federal Republic of Nigeria, because Section 251, which talks about the jurisdiction of the Federal High Court, is very clear as to cases which the Federal High Court can adjudicate on. Cases like currency, cases like immigration, cases like arms dealing. There are so many of them, like visa-related issues, passports. Those are requisite cases the Federal High Court can hear and have jurisdiction on. But on matters concerning the federal government and the state, or the president and the governor, as the case may be, Section 232 of the 1999 Constitution, subsection 1, is very clear that Supreme Court has original jurisdiction to hear matters between states and the federal government, or matters between the National Assembly or the federal government. Okay, so the judgment of Justice Omotosho of Federal High Court is in line with the provisions of the 1999 Constitution. But you see, because of the perception of Nigerians as to what has been happening in the judiciary, so when judgments like this are given, people will say, oh, they have come again, they have favored a particular party and all that. No. This judgment is in line with the law. It's in line with the provision of Section 251 of the 1999 Constitution. The judge in that judgment went ahead and referred them to the Supreme Court. We can hear where the judge said that it is only the Supreme Court that can litigate on this matter. And the judge is clear on that, following the provision of Section 232 of the 1999 Constitution, which confers original jurisdiction on the Supreme Court.
Now, so in your opinion, the judgment of Justice James Omotosho is in line with the Constitution on the issue of jurisdiction, correct?
Yes, so on the issue of jurisdiction, on the issue of locus standi, and also on the issue of course of action. Yes, a reasonable course of action arose in that matter, which was simply whether the president has the powers to suspend the elected governor and the elected House of Assembly member. That's a reasonable course of action. But why that action failed is because the parties who brought the action to court were incompetent.
All right. Now, we are looking at the course of action now, which right now is my interest. While delivering the judgment, you know, he also mentioned that the president had the right under Section 305 of the Constitution to suspend, not declaring state of emergency now, right? But I'm looking at the suspension of elected officials, that's the executive and the state assembly. Do you agree with Justice James Omotosho that the president had the right to suspend them?
Well, at this point, that is a question of the Supreme Court to determine.
But you're saying that his judgment is in line.
See, we are looking at, you see, when an incompetent party brings an action to court, that action is liable to be struck out. So the Federal High Court did the right thing by delivering that judgment yesterday and striking out the matter. Now, he referred them to the Supreme Court. Now, it behoves on the proper parties to that suit, who would have been the governor of Rivers State, Governor Siminalayi Fubara, or the House of Assembly members, to bring that action. But at this point,
the PDP governors took this matter to Supreme Court, and Supreme Court is yet to give judgment 6 months down the line.
That's true. The PDP governors bringing that action to court, I may want to say something, but I don't want to, preempt the position of the Supreme Court. But going by what we said before, proper parties to a suit are the competent parties to bring an action to court. If an incompetent party brings an action to court, that action is liable to fail, unless on a representative capacity, when the person who is originally the party to the suit authorizes you by way of attorney, then you can do so. But when you are not a party that is directly affected, you bring an action to court, it will fail.
Now, the question I asked earlier, which you did not answer me, rather you now referred to Supreme Court. I am asking you this question because Justice James Omotosho, while delivering judgment, said that the president had the right to suspend elected officials, while declaring state of emergency, and his reason is to avert, breakdown of law and order. Yes, under 305. the law, the Constitution provides for state of emergency if there is an actual or imminent threat, right, to peace, or if there is a threat or an actual breakdown of law and order. So one could say, all right, the president, declared state of emergency in line with the Constitution to avert, further breakdown of law and order. But now, nowhere in that Constitution does the president have the power to suspend elected officials. This is where my interest lies, suspension of elected officials. And Justice James Omotoso is saying that the action of the president is constitutional. I want that to make sense to me. But I'm asking you this question because you actually said that everything that Justice Omotoso said, in line with that judgment, it aligns with the Constitution. So this is where my interest is.
Yes, for purpose of clarity, in every judicial pronouncement, there are the actual judgment and obiter. Okay? If you look at the excerpts of that judgment, though the certified true copy is yet to be out, but if you look at the excerpts of that judgment, Justice Omotoso based his rulings on three major factors: cause of action, parties to the suit, and jurisdiction, which was what we recapped earlier, that before an action is brought to court, a lawyer does its work by considering these three factors. Okay, so he may have made other statements by way of obiter, but in my position and what is written in the Constitution of Federal Republic of Nigeria, we can't find anywhere the Constitution authorizes the president to suspend an elected governor. The president does not possess that power. We posited this from the onset. The president never had the power under the Constitution of the Federal Republic of Nigeria to suspend an elected governor, an elected House of Assembly member. He doesn't have the power, but let's be patient with the Supreme Court.
Now, if you say that the president does not have the power, and that nowhere in the Constitution was the president given the power. Now, one would say that, first question, River State's crisis, the peculiarity of River State crisis, was it covered in Section 305 of the Constitution?
The peculiarity of what happened in River State wasn't covered at all.
Now, if
that section, but going by the provisions of 305, the president have the powers to invoke emergency rule.
Now,
okay, but the area he doesn't have or he couldn't have invoked was suspending.
Now we are coming down there. Now, if the peculiarity of River State crisis was not covered in 305, one would say that the president, is it safe to say the president cannot be accused of breaking a law that does not exist? One, Section 305 provides for emergencies like war, situations like war, natural disaster, threat to economy, breakdown of law and order and all of that. But it does not in any way cover political crisis where there is no government, according to Supreme Court judgment. Because probably the Constitution never envisaged a situation where a state will be without government, right? So the 305 of the Constitution did not cover where the executive and state House of Assembly are at each other's throats. That's one. Now, just like the Constitution is silent on the peculiarity of River State's crisis, or the Constitution is silent on political crisis, the Constitution is also silent on suspension of elected officials if they are the arrowhead of this crisis. Let me ask you another question. Can the president be said to have broken the law if there was no law he broke? Like, I'm trying to look at it like there was no Constitution anywhere that the president broke. So can he be accused of breaking a law that never existed?
Well, it is a known fact that nobody is above the law. The position of Section 305 and also the action of the President in overreaching his powers in Section 305 ultraviolates completely the Constitution of Federal Republic of Nigeria.
Which part of the Constitution did he overreach?
He overreached the part that, you know, where we are yet to find out where he assumed the powers to suspend Governor Fubara.
Yes, I know, but the question would be, which exact section of the Constitution in 305 did he overreach? That
particular position is not captured anywhere.
Then if it is not, that's the question. If it is not captured in the Constitution,
that section.
Wait, if it is not captured in the Constitution,
he took an action.
Can he be said to have broken a law that in the first instance does not exist?
You can only determine that when he ceases to be president. Because the man is clothed with huge immunity. He's clothed with immunity that the law cannot touch him at this point. We see just recently Nicolas Sarkozy have just been sentenced as a result of an action he did, something he did while in office. So when the immunity eluded him, the law can catch up with him.
What I'm saying, in the case of, hold on, these people you're mentioning now, there were laws that they broke. And the long arm of the law got to them. In the case of President Bola Tinubu and Rivers State emergency, I am trying to see the law that the president broke. Now, what Justice James Omotosho, when he was speaking, he, in his obiter, like you said, he made allusion to averting disaster, which is covered in 305. In fact, the political crisis in Rivers State at some point became a threat to the economy of the nation, which is predominantly oil. And one could say that not only was that emergency, declared by the president to avert disaster, it was also to prevent further breakdown of law and order that is a threat to the national economy. That is covered by the Constitution. Now, I am looking at the area of the emergency rule that is not covered by the Constitution. The governor, having enjoyed immunity as well, broke the law. And one could say these are the laws that the governor broke. We could say this is this is that, this is that. Now, the Rivers State House of Assembly were at some point derecognized by the governor because of the issue of cross-carpeting, which of course, people could hold on to the Constitution to say this is what the argument is about. But in the case of the president, you're saying his actions were ultra-virus. And I'm trying to find out which part of the Constitution did he break? Because the Constitution, suspending or not suspending elected governors, governor and House of Assembly, does not exist. That is number one. And then number two, the president having the power or not having the power does not exist. And then number three, the state of the emergency declaration law in 305 does not cover political crisis, wherein the governor and the State House of Assembly, are the arrowheads of the crisis that had plunged the state into a major conundrum. So if there are no laws that one could say he broke, can the president be said to have broken the Constitution? Now, if you say the president broke the Constitution, can you give me the section of the Constitution the president broke? I think it's simple enough.
Yes, the president did not break any section of the Constitution. But what he did was he only overreached that section by taking an action that was not captured in the Constitution. Okay. So it's, in fact, see.
So he did not, long and short of the whole story is that he did not break.
Yes, he did not break the Constitution of Federal Republic of Nigeria. Okay. But he overreached his actions. See, one might look at this clearly, that what happened in Rivers State, the emergency declaration was just an intent for state capture. The president wanted to take full control of the state because of 2027. It's very clear. You see, Lonisha, Nigeria is becoming a playground.
When you say it was for state capture, now the question would be, there was attempt at political solution, yes?
We knew all that.
Did it work?
It never worked.
Good.
Supreme Court gave its judgment.
Hold on. Before Supreme Court gave its judgment, there have been judgments from the lower court to the appellate court. Did it work? It did not. And when Supreme Court gave its judgment, did it also work? It did not. In fact, at that point now, things degenerated to actual threats of impeachment. And on one hand, pipelines were now being
economic sabotage.
Exactly. Now, at the end of the day, how can you say it is a state capture when, in the first instance, there was no government, according to Supreme Court judgment?
So
if political solution failed, legal solution failed, what could have worked at that point in time?
Lonsha, why I posited that what happened in Rivers State, during the declaration of the emergency, it's an intent to capture political power in Rivers State is simple. The president couldn't have suspended the governor.
Okay, what should he have done that would have worked?
The president couldn't. See, you don't remove an elected governor from seat. He also was elected. The same way the governor was elected, he was elected too.
If the president had declared state of emergency and with the governor still seated and the House of Assembly still seated, would there have been solution?
Yes, of course.
Make it make sense to me.
When you declare emergency, you strip them of security. Yes, of course, that should be the right thing. Strip them of security, but they remain in power.
So now, will it stop impeachment from happening?
Yes.
Good luck. When you talk of good luck, Ebele Jonathan, would that be a fair assessment?
Yes, of course. We are looking at Section 305 and declaration of emergency.
Issue in the state where Goodluck Jonathan declared emergency is not the same.
Yes,
with that of Rivers State. So you cannot actually say this is what it is.
But don't also forget that we are looking at the section that authorizes the president to declare state of emergency. The scenario might be different, but wielding the power, where does this power,
now, which boils down to the question, let's just assume that the president had left them. Will it have stopped the impeachment from happening?
Impeachment is a legal process.
So hold on, the impeachment will still have happened.
Yeah,
good.
It's a constitutional process.
We are following your thoughts.
Yes.
The impeachment would have happened. Now, while that impeachment process is going on, the governor is stripped of security. The Rivers State House of Assembly members will be stripped of security as well, correct?
Yes, and the military will take over.
And then impeachment would have happened with everything that was going to play out.
No, Lonsha,
one would say, wouldn't that set the stage for a bloodshed that Rivers State would never have experienced?
No, I take exception to that. I take exception to that. If the president had declared the state of emergency in line with the provision of Section 305, that impeachment wouldn't go on.
Okay, what would have happened?
That impeachment wouldn't go on because emergency rule would have taken over. At that point, the governor will stay mute, the assembly will stay mute, and the military will overrun the state until the position is calm. At that point, legislative activities would have been either mute or suspended.
The legislature, according to the Constitution, the National Assembly legislates.
No, in this instance, no, we are looking at the position you took.
Wouldn't the National Assembly still be legislating?
No, in this position you took.
Okay, go ahead.
Don't forget you posited something. So we are
looking at your own position.
Yes.
If you're saying that they shouldn't have been suspended, which means they will still be in acting capacity.
Lonsha, let us
now you're saying no, that what they should have done is they would have just been mere figureheads, while military will now rule the states and National Assembly will legislate. Isn't that the same thing with what Ebas did?
No.
National Assembly. The only difference was that they were suspended.
Yeah, the only difference here were that the governor was suspended and removed from office temporarily.
As well as the
sole administrator was appointed to sit at the office of the governor. That was a different scenario altogether.
Okay.
That is the area I think the president or travail.
You also forgot that the State House of Assembly was suspended as well.
Of course,
and National Assembly took over. Which is in line with the Constitution.
Which is in line with the Constitution, because in a position where the state legislature couldn't do its job, the National Assembly will do it for them. Okay? But in this case, we are looking at emergency rule. The president has the powers to declare state of emergency, because the reason given by the president is cogent enough.
So now, I'm also trying to make it make sense. Now, if the governor was still there as the governor, you said he would be mute.
Yes, of course.
Ordinarily,
he should be stripped of his powers temporarily, but you can't vacate him from office, because he is an elected governor.
He will be stripped of his powers. He will be mute, stripped of his powers, but still occupying that office.
Yes.
Okay, more like a figurehead.
A figurehead. While the security agencies will be out there to maintain law and order.
Hold on, security agencies will be out there to maintain law and order. Now, in that instance, who pays salaries? The governor will still pay salaries.
Of course, you can't strip him. It is a constitutional power.
If that is the case,
he can only be removed there by death.
Hold on. If that is the case, how is that fair? If the Supreme Court judgment is upholding the position of the State House of Assembly, and the governor is being found guilty by the Supreme Court judgment, and clearly the Supreme Court says there is no government in the state, and even after that statement is made, the governor did not, hasten to do the right thing, and then threat of impeachment starts, and then you're saying that state of emergency should have been declared, and in that state of emergency, of course, National Assembly will legislate for the state, thereby suspending the functions of the State House of Assembly. Meanwhile, the governor will still exercise his powers as the governor of the state, but the only difference is that there will be increased military presence in Rivers State. How fair is that? Make it make sense to me how that could have been a solution to Rivers State crisis. Because now the same person who is found guilty is being shielded by the same constitution, while the people who have been on the receiving end of that person will be suspended. Make it make sense to me, like their functions will be suspended. Yes. I need you to balance this and tell me where there is equity and fairness in the constitutional provision that you are proposing.
Laurentia, the Constitution of Federal Republic of Nigeria is still a working document. We have not gotten it right with the Constitution. I think what has happened in Rivers State is also an eye-opener to the National Assembly, letting them know that they have more work to do. What has happened was never captured in the Constitution, but it happened. It happened. We have even seen a situation where the highest court of the land have remained silent since the PDP governors filed that suit. But other suits that were recently filed, they have conclusively given judgment on them. We know all that. What we are trying to say is, jurisprudentially, the Constitution of Federal Republic of Nigeria have a lot of flaws. The National Assembly still need work to do, still have a lot to do in our Constitution. And also, it is also an eye-opener to politicians in Nigeria. And also a time for the president also to reflect on some of the actions he took during this emergency time. Because with the position of the law is very clear as to Section 305. He never had that power to suspend Governor Fubara, because Governor Fubara was elected the same way President Bola Tinubu was elected by the people. So it is only the people that can say no by way of voting him out, or, God forbid, by death or by impeachment. That's why I said impeachment is a legal process, a constitutional process. So if Governor Fubara would have been impeached, I don't think anything wrong.
But then one would say to a large extent that in view of everything that has happened in Rivers State, well, to a large extent, the controversial move by the president had brought some semblance of sanity in Rivers State. And I am hoping and trusting that all the parties involved, having gone through what we went through in the past 6 months, would not want a repeat of that. And as we move on to the next story, like I had posited and asked you earlier, if the president, if there were no constitutional, like you said earlier, the president did not break any law. There was no constitution.
He did not commit any crime
that he broke. So if there was no constitution in Section 305 that one could say the president broke, then, well,
nothing will catch up with him after his tenure.
You're using semantics. He said he didn't break the constitution, but he overreached.
He overreached his powers.
He did not break the constitution, but he overreached
his powers.
Well, I think Supreme Court will have to, differentiate that for us.
Yes, whether he did or not, but I still have my reservations on that judgment, which I can't say now, pending the Supreme Court judgment.
Well, the interesting things still remain.
Interesting times ahead.
Interesting times ahead. And in Rivers State, I still believe that even currently in Rivers State, there are still interesting times. Things it's not in my place to bring to the public, but then, interesting times ahead.